Good morning, Alex and friends. I'm Grace. Today is Wednesday, July 9th, 2025, and you're listening to Alex's News. The weather in Riverside today will reach a high of 98.9 degrees Fahrenheit, with a low of 71.1 degrees. It's going to be a hot one, so remember to stay hydrated and seek shade if you're spending time outdoors. Coming up on Alex's News, we'll explain the Supreme Court's reasoning behind its recent decision that allowed federal layoffs to resume. Then, we'll head to California, where police education reform is drawing scrutiny and being labeled as watered down. All this and more right after the break on Alex's News. Stay tuned. We begin this morning with a seismic shift from the nation's highest court, a ruling that could send shockwaves through the federal workforce. The Supreme Court has delivered a significant decision, effectively giving the green light for the Trump administration to resume mass federal layoffs. For more on what this all means, we turn to our reporter, Ethan. Ethan, this sounds like a major development. Walk us through it.
Grace, it certainly is a pivotal moment. The Supreme Court, just yesterday, on Tuesday, July 8th, 2025, lifted a lower court injunction. This action now allows the Trump administration to move forward with what are called reductions in force, or RIFs for short, which are essentially large-scale federal layoffs. This decision, according to NPR, clears the path for the administration's expansive plans to reorganize and downsize the federal workforce, potentially impacting hundreds of thousands of federal employees.
Hundreds of thousands, Ethan? That is an astonishing number. What is the administration's stated reason for such a sweeping move?
The genesis of this whole legal battle dates back to February 2025, when President Trump issued an executive order mandating that government agencies prepare for these large-scale reductions. An accompanying memorandum, as reported by both NPR and CBS News, asserted that the federal government is, quote, costly, inefficient, and deeply in debt, end quote, attributing these issues to, quote, unproductive and unnecessary programs, end quote. The administration's plan includes measures like hiring only one employee for every 4 departures, removing underperforming staff, and allowing temporary positions to expire, according to NPR.
So it's all about efficiency then, and I believe there's a specific department leading this charge?
That's right, Grace. These efforts are spearheaded by the President's Department of Government Efficiency, or DOGE. Yes, that's DOGE, like the popular internet meme. This cost-cutting task force was initially led by none other than Elon Musk, as CBS News uncovered. The administration's core argument, supported by NPR and Government Executive, is that the President, as the executive, possesses the inherent authority to direct agencies to conduct these RIFs for reorganizations without requiring additional statutory authorization, all in the name of, quote, government efficiency, end quote. They want to, quote, critically transform, end quote, the federal government and expand presidential power, believing that many career federal employees prioritize personal political preferences over the elected president's agenda.
Fascinating. So this isn't just about cutting costs, but also about shaping the very nature of federal power. How did this executive order initially get blocked?
Well, it faced immediate legal challenges, Grace. Labor unions, including the American Federation of Government Employees, along with various advocacy groups and local governments, filed lawsuits. They contended, as reported by NPR and CBS News, that President Trump had, quote, exceeded his authority, end quote, by mandating mass layoffs without, quote, congressional approval, end quote. They even highlighted that Congress had rejected similar proposals during his first term. In May 2025, U.S. District Judge Susan Ilston in California temporarily blocked the order, issuing an injunction that applied to 22 federal agencies. Judge Ilston and later the U.S. Court of Appeals for the Ninth Circuit both found that while presidents can restructure federal agencies, such actions typically require congressional approval, and Trump's executive order, according to NPR, Government Executive, and CBS News, quote, far exceeds, end quote, his constitutional powers. Opponents argued that without the block, quote, critical government services would be lost, end quote, and it would be, quote, impossible to reverse the layoffs, end quote.
So what changed yesterday at the Supreme Court?
The Justice Department appealed to the Supreme Court for emergency relief, arguing the lower court's injunction was based on an incorrect interpretation of the executive order's legality. And yesterday, Grace, the Supreme Court, in an 8-1 decision, sided with the administration. According to NPR, Government Executive, and CBS News, they lifted the lower court's injunction, allowing the administration to proceed with the layoffs while the legal battle continues. The court's order was brief, stating that the government was, quote, likely to succeed on its argument that the executive order and memorandum are lawful, end quote. However, it's crucial to note that the court explicitly stated it expressed, quote, no view on the legality of any, end quote, specific agency RIF plans, only on the legality of the initial executive order itself. This leaves open the possibility for the issue to return to lower courts for further constitutional review, as NPR and CBS News have detailed.
So this is not the final word, just a green light to proceed for now. I understand there was a lone dissenter in this decision. So what are the immediate consequences of this decision? Are we going to see layoffs start tomorrow?
Following the Supreme Court's decision, Grace, dozens of RIF actions that had been stalled are now expected to move forward swiftly, according to Government Executive. Agencies like the Department of Health and Human Services, or HHS, that had already issued RIF notices may now finalize thousands of staff offboardings. Other departments, including Interior, Agriculture, and State, are anticipated to quickly issue new notices to thousands more employees, although the precise timing remains uncertain and could be complicated by agency-specific lawsuits. Prior to the lower court's block, thousands of federal employees had already lost their jobs. By late April 2025, the DOJ's efforts had already resulted in approximately 260,000 federal employees being fired, resigning, or taking early retirements. For example, the Veterans Administration had planned to lay off 83,000 employees, though that number was recently reduced to about 30,000.
How are both sides reacting to this?
White House spokesman Harrison Fields hailed the Supreme Court's decision as, quote, another definitive victory, end quote, for the president, as reported by NPR. Attorney General Pam Bondi praised it as a victory that halted, quote, lawless lower courts, end quote, and would lead to more efficient federal agencies, according to CBS News. Conversely, the coalition of groups challenging the layoffs expressed deep disappointment, calling the decision, quote, a serious blow to our democracy, end quote, that, quote, jeopardizes essential public services, end quote, arguing that mass layoffs without congressional approval are unconstitutional, according to NPR and CBS News. Democratic lawmakers have vowed to continue fighting these cuts through legislative and legal means, warning of long-lasting damage to government services and agencies, as Government Executive noted.
Ethan, you mentioned this isn't the final word. What's next for this case?
That's right, Grace. All rulings so far have been on a preliminary or emergency basis, according to Government Executive. The case still needs to be argued on its full merits, a process that will take months. While the Supreme Court has shown sympathy with the administration's perspective at this stage, a final decision on the merits could be anticipated by June 2026, which is nearly a year from now. The full merits review will center on the fundamental constitutional principle of separation of powers, specifically the interplay between presidential authority under Article 2 of the Constitution and congressional authority under Article 1 regarding the structure of federal agencies and the employment of federal workers.
So a deep dive into the Constitution itself. What are the core arguments we expect to hear?
The administration's legal arguments will likely rest on the president's inherent authority to manage the executive branch, invoking the, quote, unitary executive, end quote, theory, asserting broad discretion over personnel decisions for efficiency. They may cite precedents like Myers v. United States from 1926, which affirm the president's broad discretion to remove appointed officials. On the other side, the plaintiffs will argue Congress's prerogative to create and structure federal agencies, define their functions, and regulate federal employment. They'll contend the executive order exceeds the president's authority by circumventing detailed statutory schemes for federal employment, like the Civil Service Reform Act of 1978. They may also invoke the non-delegation doctrine or argue abuse of discretion. Precedents like Humphrey's Executor versus United States from 1935 and Morrison versus Olson from 1988, which established limits on the president's removal power, will be crucial. It's truly a clash of constitutional interpretations.
Beyond the legalities, what about the practical implications of such mass reductions? Does empirical evidence support the idea that this will lead to greater efficiency?
That's a great question, Grace. While the stated goal is efficiency and debt reduction, empirical evidence and expert analyses suggest a more complex, often negative, long-term impact on government services, cost-effectiveness, and agency functional capacity. Studies indicate that large-scale reductions, particularly through rapid firings, lead to a significant loss of institutional knowledge and expertise. This, quote, institutional memory drain, end quote, can result in operational inefficiencies, repeated mistakes, and a decline in service quality, leaving agencies unprepared for challenges. Reduced staffing can also lead to delays and disruptions in public services, affecting things like loan approvals, public safety, veteran care, and even Social Security services.
So instead of streamlining, it could actually bog things down?
Precisely. While the goal is cost savings, some analyses suggest that personnel cuts alone may not significantly close the federal deficit. Estimates of savings often don't incorporate the costs of buyout offers, agency reorganization, or potential increased costs from reduced services. In some cases, cutting certain federal employees, such as those involved in tax collection or fraud recovery, might even cost the government money. What's more, workforce reductions often lead to an increased reliance on private contractors, which can create new contracting opportunities that may ultimately increase overall costs, as federal employees are often a better value to taxpayers than private firms whose billing rates can be significantly higher. This shift can also reduce public access to services, weaken accountability, and introduce new security threats. Finally, the uncertainty created by cuts negatively impacts morale among remaining employees and makes it harder to recruit top talent.
Lot to chew on there. Are there alternative strategies for government reform that don't involve such drastic layoffs?
Absolutely, Grace. Modern democracies have explored alternative or complementary government reform strategies to achieve efficiency and cost savings by addressing systemic bureaucratic issues. These include digital transformation and e-governance, leveraging technology to automate processes and improve service delivery. We also see lean government initiatives, which apply principles to identify and eliminate waste, and performance-based budgeting, linking resource allocation to measurable outcomes. Other strategies involve regulatory reform, streamlining existing regulations, sunset clauses in legislation, which automatically repeal or require review of outdated laws, and public sector innovation labs to foster creativity. It's about working smarter, not necessarily just smaller.
A very comprehensive look at a complex issue, Ethan. Thank you for breaking it all down for us. This is definitely a story we'll continue to follow closely.
My pleasure, Grace.
That was Ethan with story 1 of 2. When we come back, we'll turn our attention to the latest developments from overseas. Stay with us. Welcome back, everyone. We have an important story to dive into now, concerning public safety and the future of law enforcement in California. The state is currently grappling with a significant legislative and public debate over new education requirements for its police officers. For more on this, we turn to our reporter, Chloe. Chloe, this sounds like a complex issue. Can you set the stage for us?
Grace, it certainly is. This push for higher educational standards for California police officers emerged directly from calls for police reform following the 2020 murder of George Floyd. Many believed better educated officers would lead to better outcomes.
And what was the initial legislative attempt to address this?
In 2020, former Assemblymember Reggie Jones Sawyer proposed a bill requiring prospective officers aged 18 to 25 to hold a bachelor's degree based on research linking higher education to less force and better decisions. But it faced strong opposition as too restrictive.
So, that initial proposal didn't quite make the grade. What came next?
Exactly. A revised version, Assembly Bill 89, or the Peace Officers Education and Age Conditions for Employment Act, the PEACE Act, was signed into law in 2021, effective January 1, 2022. This act raised the minimum officer age to 21 and mandated California's community college system develop a modern policing degree program by this year, 2025, to foster critical thinking.
Fascinating. So 5 years after the initial reform calls, where do things stand now with new legislation?
The debate has been reignited, Grace, with Assembly Member Jackie Irwin's introduction of Assembly Bill 992. This new bill proposes revised education standards, set to take effect on January 1, 2031, which is just over 5.5 years from now.
Over 5.5 years. What exactly does AB 992 propose for these new education standards?
Under AB 992, most newly certified peace officers would need one of several qualifications within 36 months of receiving basic certification from the Commission on Peace Officer Standards and Training, or POST, like an associate's or bachelor's degree or a modern policing degree. Significantly, according to reporting from the Los Angeles Times, it also introduces alternative pathways like 2 years of military experience or 2 years of out-of-state law enforcement experience. Exemptions exist for current officers or those in academies before December 31, 2030.
That certainly adds a lot of flexibility. But I understand this flexibility is precisely what's causing some friction. Why are critics calling this bill watered down?
That's right, Grace. Critics argue it significantly waters down the original reform goals. Former Assembly member Reggie Jones Sawyer, author of the original 2021 law, contends AB 992 undermines his intent with too many loopholes. Former Justice Department official Arif Ali Khan stated these exceptions, quote, completely obviate the need to have any educational background. They fear these exceptions swallow the whole, negating the benefits of higher education for police officers.
So they worry it could negate the push for a more educated police force. What's the basis for their concern about these alternative pathways?
Their concern is rooted in empirical evidence. While traditional academic degrees are linked to officers using less force and fewer complaints, as ABC News has uncovered, critics argue there's limited evidence that alternatives like military experience lead to the same improved outcomes. Christy Lopez, a Georgetown law professor, also expressed concern that the bill's new recruitment task force would solely comprise law enforcement personnel.
So that's the con side of the debate. What are the arguments from those who support AB 992, especially given the statewide officer shortage?
Supporters, including all major statewide law enforcement groups, argue AB 992 is crucial to address California's pervasive police officer shortage. Staffing levels are reportedly at a 30-year low due to low wages and an aging workforce. Agencies are even offering $10,000 hiring bonuses.
$10,000 bonuses. That's quite an incentive. It sounds like a significant challenge.
It is. Los Angeles Sheriff Robert Luna recounted how his office saw a, quote, 50% immediate decline in applicants, when it briefly required a bachelor's degree. He views Assembly Member Irwin's bill as a more workable, more inclusive path forward. Supporters believe stricter degree-only requirements would be catastrophic to staffing statewide, and AB 992 helps broaden recruitment opportunities. It truly is a balancing act.
It truly sounds like a balancing act between the ideal and the practical. Chloe, thank you for breaking down this very important and complex debate for us. We appreciate your insights.
My pleasure, Grace.
We'll continue to keep an eye on this story as it progresses through the legislature. A heartbreaking situation is unfolding in Texas. Catastrophic floods tragically soaked the Texas Hill Country over the 4th of July weekend. As of July 9th, the death toll surged to at least 109 across Texas. 161 people are still missing, primarily in Kirk County. This region, known as Flash Flood Alley, was hit hard. It accounts for 94 confirmed deaths. The Guadalupe River in Hunt rose a dramatic 26 feet in under an hour. A tragic focal point is Camp Mystic, an all-girls summer camp. Floodwaters demolished cabins there. This claimed 27 campers and counselors. Among them were 8-year-old twin sisters Hannah and Rebecca Lawrence, and the camp director. Authorities face scrutiny. There was no county-wide siren warning system. Survivors described a pitch-black wall of death and no warnings. Governor Greg Abbott declared an extraordinary catastrophe. He pledged continued search efforts. President Donald Trump is scheduled to visit. In travel news, there is a big step forward in airport security. As of Tuesday, July 8th, U.S. airport travelers are no longer required to remove their shoes during security screenings. Homeland Security Secretary Kristi Noem announced this immediate nationwide change. This marks a major shift after nearly 2 decades. The shoes-off rule was implemented by the TSA in 2006. It was a direct response to the infamous 2001 shoe bomber incident. Secretary Noem credits dramatic advancements in security technology for allowing passengers to keep their footwear on. While you can keep your shoes on, existing rules still apply. These include removing belts, coats, laptops, and liquids from bags. This new policy is expected to streamline the security process. It should also enhance your overall passenger experience. Across the Atlantic, Europe is gearing up. There is a pressing call for the continent to rearm within the next 5 years. The method of how they will achieve this remains somewhat unclear. Denmark, currently holding the EU presidency, has made strengthening European defense a key priority. Prime Minister Mette Frederiksen stated Russia could pose a security threat by the end of the decade. This urgency is driven by intelligence estimates. There is also growing uncertainty about continued U.S. security assistance. This prompts Europe to stand on its own 2 feet. Ambitious plans were unveiled this past March. They include the Rearm Europe plan. This plan aims to leverage €800 billion in defense spending by 2029. There is also a proposed €150 billion loan facility to support the defense industry. NATO allies have even committed to investing 5% of their GDP annually on core defense by 2035. This push focuses on critical areas. These include air and missile defense and drones. However, challenges like funding uncertainty and political divisions make this a complex undertaking. Meanwhile, in global law enforcement, a Chinese national named Xu Zhewei has been arrested in Italy. He faces extradition to the U.S. This is in connection with a scheme to steal COVID-19 research from American universities. Xu, along with another Chinese national, Zhang Yu, was charged in a 9-count indictment. Zhang Yu remains at large. The indictment was unsealed in the Southern District of Texas. Authorities allege Xu and his county conspirators operated under China's Ministry of State Security. They hacked several U.S. universities between February 2020 and June 2021. They stole information related to COVID-19 vaccines, treatments, and testing. The group, known as Hafnium, is accused of exploiting vulnerabilities. This allowed them to compromise over 12,700 U.S. entities to steal sensitive information. U.S. Attorney Nicholas J. Gange emphasized this hacking is not just a violation of intellectual property rights. He called it an attack on American scientific innovation. He noted they have patiently waited years to bring Xu to justice. Finally, turning to Africa, the death toll from anti-government protests in Kenya tragically shot up to 31 on Monday, July 7th. This marks the highest single-day toll since demonstrations began. The state-funded Kenya National Commission on Human Rights reported these figures. They also reported 107 injured and over 500 arrested. These primarily youth-led protests were sparked by the death of blogger Albert Omondi Ojwang. He died in police custody last month after criticizing a police official. This incident, coupled with public discontent over rising living costs and police brutality, has fueled the ongoing demonstrations. The July 7th protests coincided with Sabasaba Day. This is a significant date commemorating Kenya's 1990 pro-democracy movement. Protesters also called for President William Ruto's resignation. police clashed with demonstrators. They used tear gas, water cannons, and in some cases, live ammunition. The UN High Commissioner for Human Rights has urged for prompt and transparent investigations into all reported killings, human rights violations. That's all we have for now. Today's episode was made by Alexander King with Claude Sonnet 4.0, Gemini Pro 2.5, Gemini Flash 2.5, and Google Cloud Text-to-Speech. I hope you have a great day. I'll see you tomorrow, Alex.